We're often asked what's involved in making an employment claim, how the Employment Tribunal process works, and how long it may take. The process follows a regulated format with key timeframes and statutory limits for claims. In this video, I'm going to explain the Employment Tribunal process, key terms and timings. Having worked in the North East for over 10 years helping individuals and businesses with employment law matters, I'm confident that this information will help you better understand the Employment Tribunal process. An employee may decide to go to an employment tribunal for a number of different reasons. They may not have been paid properly, they may have been dismissed, they may have suffered discrimination, they may have been treated badly because they stood up for their rights. Whatever the reason, once an employee is considering going to a tribunal, we call them the claimant, and we call their employer the respondent. The first thing the claimant typically has to do is contact ACAS to try early conciliation. ACAS is a free, independent organisation whose purpose is to try to help with workplace problems. ACAS will get in touch with the employer to see if an agreement can be reached. This can take up to 6 weeks. One of the most important things a claimant can do is to act quickly. Employment tribunal claims have very short time limits, often as little as 3 months from the date something happened. This time limit is paused once the employee contacts ACAS, which can help. If ACAS is not successful, then the next stage is to start the tribunal claim. The claimant does this by completing a form called an ET1. This can be done entirely online. The form includes details of the claimant, the respondent, the claimant's job, what the claimant says has gone wrong, and what the claimant wants as a result. The form also requires a reference number from ACAS to prove that the claimant has attempted conciliation. Again, the claimant needs to act quickly in lodging the ET1 form because quite complicated rules say when the final deadline is after ACAS conciliation. Once lodged, tribunal staff will check the information in the ET1 to make sure it's in the proper form. That can take a few days to a couple of weeks depending on how busy they are. Once they're satisfied, they let the respondent know a claim has started by sending them a copy of the ET1 form. The respondent is given 28 days to complete and return their own form, called an ET3. In this form, they can confirm or dispute the facts stated by the claimant. In some cases, they're also given the chance to raise their own claim against the employee. The next stages of the process will depend very much on what the claim is about. Claims involving discrimination will have steps of procedure that claims of unpaid holiday pay do not have. No matter the procedure in the middle, if the claim has not been resolved, it will eventually reach a final tribunal hearing. This can be anything from a few weeks to a few months after the ET1 and ET3 forms are completed. Final hearings are usually held at the Employment Tribunal office closest to where the claimant works or worked. They can take place in front of an employment judge alone or a panel of 3. Panels of 3 still only have one employment judge, but they also include 2 non-legally qualified members. One will have a background relating to employers, and the other employees. Most cases usually last for 1 to 3 days, but complex cases can be longer. Having heard all the evidence, the tribunal will listen to final arguments from both sides before reaching a decision. In most cases, the decision is not announced on the day of the tribunal. Instead, the tribunal will take some time, normally a few weeks, to consider in detail all the evidence they've heard and seen, together with the relevant law, before providing their decision in writing. If you think you might be involved in an employment claim and you're unsure about the difference between wrongful and unfair dismissal, watch our video on our YouTube channel. If you have an employment law query, start a conversation with one of our friendly and knowledgeable solicitors. Fill out a contact form on our website and we'll call you back to discuss your requirements.